Hi everyone, a very warm welcome to Thorough Newspaper Analysis. This is a combined video for the 8th and 9th of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. So first of all, we have the editorial segment, and here we're going to take up for discussion an Indian Express article. Now the title of this article is, Do Marriages Need to be Registered? What happens if there is no registration? Now, this is in light of recent Supreme Court observations on how a couple before it did not acquire the status of being the husband and wife to each other. Why? Because although their marriage was registered, but they did not perform the requisite ceremonies, their marriage did not take place, according to the requisite rituals, the ceremonies which were required under the Hindu Marriage Act. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So without further ado, let's start with the article and let's first have a look at title of it. Do marriages need to be registered? What happens if there is no registration? Let's first quickly have a look at the context of it. So last week, the Supreme Court ruled that despite an official marriage certificate, a Hindu couple before the court had not acquired the status of a husband and wife. Now, what is the reason? Why did the Supreme Court say so in spite of the fact that they registered their marriage? So the reason, please note, was that the couple's marriage was registered under Hindu Marriage Act, which is a personal law. It was not under a secular law, let's say like a special marriage act. So the marriage was registered under a Hindu marriage, under the Hindu Marriage Act, even before they performed the wedding rituals. So the parties, although registered their marriage, but they did not perform the wedding ceremonies and the rituals which are essential to the religion of Hindus when it comes to marriage. So the Supreme Court ruled that the couple who had filed divorce cases need not get a divorce because they were not married in the first place. The Apex Court's observation in this ruling, it brings to the forefront various issues on registration and solemnization of marriage. So now let's understand what is a solemnized marriage and what is a registered marriage. How are these two different? So when I talk about solemnization, please mark this word in your mind. So when I say solemnization, then immediately your mind should be diverted to performance of rituals and necessary ceremonies. So solemnizing a marriage simply refers to the performance of an official marriage ceremony with appropriate rituals. Marriage in India, as we know, it is largely governed by a gamut of personal laws, and there is a secular, non-religious law as well. And that is the Special Marriage Act of 1954. So though codified through various statutes, these personal laws, they essentially are nothing but embodiment of the religious practices, with each religion having its own set of requirements for a marriage. We'll have a look at some of these requirements later. But for now, just note that there are certain, laws. These personal laws, some of these are codified for some religions. And even though there is a codification, they are essentially, an undertone to the religious character of these rituals. So for instance, if I were to give you an example of Hindu religion and of Christians, so marriage, it is considered to be a sacrament. That is, it is a religious bond. So rituals such as the Kanyadan, the Pani Grahan, and the Saptapadi, they are to be performed. Saptapadi essentially is the practice of taking those 7 feras. And apart from that, there are other local customs also for solemnizing a Hindu marriage. In fact, this particular factum of solemnizing the marriage with performance of requisite rituals, it is given a codified, color by Section 7 of the Hindu Marriage Act, which says that these requirements are to be performed. And they've also specified Saptapadi as one of the essential rituals. For Christians, a ceremony in the church which is based on local customs is regarded as a valid marriage. For example, for the Tamil Christians, this involves tying a thali, which is essentially a chain with a cross on pendant in church. But when it comes to Muslim marriages, please note the nature there is slightly different. Muslim marriages are more in the nature of a contractual obligation. So just like for a contract, a valid contract, there are certain requirements under Section 10 of the Indian Contract Act, and one of that is there should be free consent of competent parties. So similarly here, the parties, they have to give consent, vocal consent, for marriage, and then they end up signing a nikahnama, which is the Islamic marriage contract in presence of witnesses and a qazi. Now let's talk about what are registered marriages. Registration of a marriage after it is solemnized by performing the rituals and ceremonies, it is different from a registered marriage. So commonly used terms like court marriage or a registered marriage, it refers to the non-religious or civil marriage which is performed under the Special Marriage Act, which is the secular law, and not under, let's say, the Hindu Marriage Act. So a marriage which is performed under this law, it is essentially a solemnization in court or in a registrar's office without performance of any rituals. There is no undertone of any religious ceremonies here. However, marriages under the personal laws, let's say the Hindu Marriage Act, become valid only after there is performance of the rituals which are prescribed by the religion concerned. So a marriage without any rituals is only valid under the Special Marriage Act and not under the Hindu Marriage Act. And in this particular case, what happened was the registration was done under the Hindu Marriage Act, but no ceremonies were performed. Under Section 8 of the Hindu Marriage Act, it gives powers to the state to register marriages which are solemnized as per the requirements of Section 7. Similarly, the Indian Christian Marriage Act of 1872, it provides the procedure for solemnization of Christian marriages and their registration. For Muslims, the nikahnama, which is issued by the qazi, it outlines the terms of the marriages, although not a public registration under a statute, but it is largely accepted. Separately, several states like Assam and the UT of Jammu and Kashmir, they have their own laws for registration of Muslim marriages and divorce, but they are very rare. So now let's talk about what if a marriage is not registered, then what happens? So please remember, there is an entry under the concurrent list, the third list of the 7th schedule of Indian Constitution, which deals with marriages and divorce. And there's an entry 30, which deals with vital statistics. Now, this includes statistics related to births, deaths, and marriage-related statistics, and registration is also included here only. Although there is a central legislation on the subject, which is the Births, Deaths, and Marriage Registration Act of 1887, but here we'll note that although the registration of births and deaths, it is actively done, but when it comes to marriage, it is not, it does not have a very robust application. States have their own laws, and in some states like Karnataka and Delhi, registration of marriage, it is mandatory, it is compulsory. But please remember, when it comes to marriage registration certificate and validity of marriage, we'll see what is the dynamics there. So a certificate of a marriage registration, it is useful for various purposes. Let's say if somebody is applying for a spousal visa or a joint medical insurance, then to prove the fact that, the parties are married, a certificate of marriage registration, it is needed. However, not registering a marriage, it cannot be the sole ground to declare a marriage invalid. Why? Because we knew that in order to hold a marriage valid, the performance of requisite ceremony is needed, and registration is not compulsory. So then how can it have a say on, let's say, solely being a ground for declaring a marriage to be invalid if there is non-registration? So that is what is written, that not registering a marriage cannot be the sole ground to declare it invalid, since registering a marriage itself does not make it valid. So not registering also cannot make it invalid. So when the validity of a marriage is contested, then the marriage certificate alone, it is not sufficient to prove the marriage. Rather, you have to prove a couple of other things like, the marriage album, the video footages to say that you performed the ceremonies of marriage. There is an exception, however, to this, and that is under the Special Marriages Act. There is a section in this act, which is the section 13, subsection 2. I would like to read this out. It says that on a certificate being entered in the marriage certificate book by the marriage officer, the certificate shall be deemed to be conclusive evidence of the fact that a marriage under this act, the Special Marriage Act, it has been solemnized, and that all the formalities, let's say respecting the signatures of the witnesses, they have been complied with. So this means that if a marriage is performed under the Special Marriage Act and a certificate has been issued under this act, then this certificate is a conclusive evidence of the fact that a marriage has been performed under the Special Marriage Act, and secondly, all the formalities about the signature of the witnesses, they have been complied with. In Muslim and Christian marriages too, registration takes place almost immediately once the solemnization of marriage is done. Because in the presence of witnesses, there is a nikahnama which is signed, but this is rarely, the practice under Hindu marriage. So for a Hindu marriage, the priest does not generally, register a marriage. However, in law, there exists a general presumption of marriage when a man and a woman, they cohabit continuously, even if there is no direct evidence of marriage. There is a section under the Indian Evidence Act, which is section 114, which says that court may presume certain facts. By may presume, we mean section 4 of the Indian Evidence Act, that the parties can rebut this presumption, and also the court can call for, additional evidence to rebut this presumption. So it says that the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, to human conduct, to public and private business in their relation to the facts of a particular case. This means that if, let's say, there are two parties, they are living together and they have been living together for a really long time, they're holding out to the public at large that they're living together in so and so capacity, and their relatives, their family, their public generally perceive them to be husband and wife, then there is a presumption in favor of their marriage. A valid marriage as per rituals, it might be a key. It might be key in determining who is a rightful spouse. So let's say there is a husband, there are two women, they're contending that I am the lawfully wedded wife. Now here, if the husband can give proof of a valid marriage as per the rituals in form of the photo album or the video footages, then there is a presumption in favor of the fact that, let's say, this is the lawfully wedded wife. So this is how the proof of the marriage which is performed following these rituals and ceremonies, it can aid the court. And similarly, it happens in inheritance cases as well. So proof of performing a valid marriage as per rituals like photos and witnesses, etc. Proof of a long cohabitation as spouses through acceptance by family, friends, or even children. It is evidence of a valid marriage. A marriage certificate has corroborative value in these cases, but cannot be counted as evidence in itself. It is not substantive piece of evidence. It is not considered that the matter which is contained in the certificate is, true. It is the truth of the fact which is contained in it. It is generally of corroborative value. And now we proceed to the next segment. So now let's start with the national news, and this is the first update here. India and Ghana strengthen financial integration for enhanced trade. India and Ghana, they're poised to integrate their payment systems. The payment system for India is UPI, the Unified Payment Interface, and for Ghana, it is GIPS. GIPS stand for the Ghana Interbank Payment and Settlement System, and this is done to facilitate instant and cost-effective fund transfers between the two countries. Next up is an update in the category of sports for today, and this is a very proud moment for us as a country. Indian men's and women 4x400 meters relay teams, they have qualified for the Paris Olympics. The Indian men's and women 4x400 meters relay teams, they have qualified for the Paris Olympics after finishing at the second position at the World Athletics Relays in the Bahamas. Let's talk about the team for the women's category. So we have the group of Rupal Chaudhary, M.R. Puvamma, followed by Jyotika Sri Dandi, and then we have Subha Venkatesan. They clocked 3 minutes and 29.35 seconds to finish at the second position behind their Jamaican counterpart. The 26th edition of ASEAN-India Seniors Official Meetings in New Delhi held. The 26th edition of ASEAN-India Senior Officials Meeting, it was held in New Delhi. It welcomed the positive developments in ASEAN-India Comprehensive Strategic Partnership and shared mutual commitment to further augment the relationships. Sri Lanka inks pact with Adani for wind energy. Sri Lanka has entered a 20-year power purchase agreement with India's Adani Group, Adani Green Energy Limited, for 2 wind power stations developed by the company. Please remember the collaboration. It is between Adani Green Energy Limited and Sri Lanka. World first CNG motorcycle to be launched in June. Bajaj Auto, which is led by the Managing Director Rajiv Bajaj, it is all set to introduce a groundbreaking innovation in the world of motorcycles. What is that innovation? It is world's first CNG-powered motorcycle, which is scheduled for a launch on 18th of June this year. Another update, another proud moment in the segment of sports for our country. Indian contingent has secured 43 medals at the Asian Boxing Confederation Under-22 Championship. In boxing, the Indian contingent, it has wrapped up their electrifying journey at the Asian Boxing Confederation Asian Under-22 and Youth Boxing Championship with a remarkable haul of 43 medals, and this happened at Kazakhstan, which is the host country for this event. As far as the medal tally is concerned, this 43 medal, it is bifurcated in this number. We have 12 gold medals, 14 silver, and 17 bronze. India is at the second position, just one behind the host country, which is Kazakhstan. And as far as Kazakhstan is concerned, its medal tally is 48 medals. This is an important update because it has an interrelation with law. So the Delhi State Legal Services Authority, it has launched a program to reshape the lives of undertrials and help them reintegrate with the society. So what is this program? Who are the collaborating agencies here? What is its purpose? Please note down that for your exam purposes. So the name of this project is Project Saksham. Its objective and agenda is to provide skill training to individuals to undertrials within the Tihar jail complex, marking the largest initiative of its kind in India. And this is a collaborative effort of Max Life Health Foundation and Delhi State Legal Services Authority. Next up is an update in the category of important days for today. So the important day concerned is 8th of May. What is it? What is the significance of this day? So it is observed as the World Red Cross and Red Crescent Day. This day, it acknowledges and appreciates the work which is done by the Red Cross and Red Crescent societies, the International Committee of Red Cross, and the International Federation of Red Cross and Red Crescent societies. Now, let's talk about the theme for this year. So the theme is, everything we do, it comes from the heart. Now, let's understand the historical background of this particular day. So, at the 14th International Conference of Red Cross, which was held in London, England, all the delegates way back in 1938, they decided that we are going to observe 8th of May as the International Red Cross Day. Now, a question might arise in your mind as to why 8th of May? Why not, let's say, 9th of May, 10th of May, why 8th? So 8th of May, it is important because for that, let's go back to 1828 in Switzerland. On 8th of May, in 1828, in Switzerland, we saw the birth of Henry Dunant. Now, who is he? He's the co-founder of Red Cross. And hence, 8th of May is celebrated, observed, commemorated, whatever you may want to call it, as the World Red Cross Red Crescent Day. Now we proceed to the international segment, and first we have an update from Panama. So we have this update with respect to the presidential elections there. Jose Raul Mulino, he has emerged as the victorious candidate in Panama's presidential election. He has secured nearly 35% of the counted votes and overall, or with over 92% of ballot tallied. India-Nigeria Local Currency Settlement System Agreement. India and Nigeria, they've agreed to finalize the Local Currency Settlement System Agreement with the aim of enhancing bilateral trade. The agreement to be settled in Indian rupees and Nigerian naira. This is the currency of Nigeria. It was discussed during the second session of India-Nigeria Joint Trade Committee in Abuja. And this has brought us to the legal updates category, with the first update coming from the Honorable High Court of Bombay. Courts cannot interpret conditions of advertisement contrary to plain language of the same. A division bench of the Bombay High Court decided a writ petition, and while doing so, the court held that the court, in the garb of judicial review, it cannot sit in the chair of appointing authority to decide what is best for the employer and interpret the conditions of advertisement contrary to the plain language of the same. The case concerned here is Ashok Malinath, Halsangi and others versus the state of Maharashtra and others. Next up is an update from the Honorable Supreme Court. So the Supreme Court has held, the Supreme Court issues directions against misleading ads, self-declaration forms by advertisers. Influencers must endorse responsibility. The Supreme Court, in a pivotal order, has passed a slew of measures and directions to protect consumers from misleading advertisements. The directions included equal responsibility of advertisers and those who endorse these ads, qua misleading ads, and the uploading of a self-declaration form by advertisers before issuing any advertisement. Regarding the first direction, the court noted that endorsements by public figures, influencers, celebrities go a long way in promoting a product. In this backdrop, the court stated that it is imperative for them, for these influencers, these public figures who are endorsing these products. So it is essential for them, and it is imperative for them to act with responsibility when endorsing any product in course of advertisement and taking responsibility. The court drew its strength from the Central Consumer Protection Authority guidelines, which specifically defined bait advertisements, endorsers, and surrogate advertisements. The court also referred to Guideline 13, which requires due diligence for advertisement endorsements. The name of this particular matter is Indian Medical Association versus Union of India. Next up is an update with respect to the Juvenile Justice Act. Another important update, especially for judiciary aspirants. So 3 months time limit for preliminary assessment of juveniles as per Section 14, subsection 3, it is not mandatory. The Supreme Court has held that the time limit of 3 months, which is prescribed under Section 14, subsection 3 of the Juvenile Justice Care and Protection Act of 2015, for ascertaining the mental and physical capacity of a child below the age of 16 years to commit a serious offense, it is not mandatory, but it is directory. The court observed in this respect, and I would like to quote that out. As in the process of preliminary inquiry, there is involvement of many persons, namely the investigating officers, the experts whose opinion is to be obtained, and therefore the proceedings before the board, the JJ board, where for different reasons, any of the party may be able to delay the proceedings. In our opinion, the time so provided under Section 14, subsection 3, it cannot be held to be mandatory, as no consequence of failure have been provided, as is there in case of inquiry into petty offences in terms of Section 14, subsection 4 of the JJ Act. The name of this particular matter is Child in Conflict with Law through his mother versus the state of Karnataka and another. Another update from the Supreme Court, UP Consolidation of Holidays Act. That is the subject matter of this update. Consolidation officers can't take away ownership of tenure holder and grant it to another. In a recent decision concerning the UP consolidation of Holdings Day, I'm sorry, this is not holidays, it is Holdings Act. Let's talk about this act again. So in a recent decision which concerned the UP Consolidation of Holdings Act of 1953, the Supreme Court held that the consolidation officer is not vested with the power to take away the vested title of a tenure holder and grant ownership to some other person in the property. The name of this matter is Prashant Singh and others, etc. versus Meena and others, etc. So this has brought us to an end of our TNA. Thank you so much for watching, and have a wonderful day ahead.